There he is. My God. You got your favorite going to church jersey? I don't even know what that means.
I want the truth. You can't handle the truth.
Charles Johnson.
Your Honor, he's present. He's taking him.
Was that him?
Yes. I can I
Maybe.
2-week reset since now that he's in custody.
Well, okay, they took him in custody. Then, Tommy, what's he in custody for?
Yeah, misdemeanor warrant for assault, Judge.
Okay, so well, he's going to make that bond in a flash, and that doesn't get us anywhere. The point is this is a GPS charging issue,
Yes, Your Honor.
right? Well, that needs to get resolved
Yes, sir.
because otherwise he's just going to go out and then come back in, and we'll get him in here, I guess.
Yes, sir.
Judge, you want me to print out the information on the misdemeanor warrant?
I don't know what is when it comes to that sort of thing. I don't know what the proper procedure is for clearing out data. I'm a little fuzzy on responsibilities there. I add data. I never take data out. That is.
Yes, sir.
There he is. My God. You got your favorite going to church jersey? Let me ask you this. I don't even know what that means. VLIEG. What is that? Is that a band or a group or something?
Brand a girl made.
Sir? It's a
brand a girl made. Like,
oh, that's her brand. And she made the name up. How do you pronounce it? Vleague?
Be loud. I don't even know.
That's one. I guess that's one choice to make come into court. It wouldn't have been mine. Would you wear that to church though?
No, sir.
Why not?
Like, I just put some on.
But you wouldn't wear that to church. I wouldn't.
Exactly. Yeah.
I mean, with that face on it and all, is that? I mean, you think that it honors our creator? And
sometimes the stuff that Stephen says does make me think that if you were to say that you aren't a believer in the big guy upstairs, that you'd be even in more trouble. And that probably isn't a great thing for blindness.
Going to church? No. Well, now we're not church, but this is the Constitution, and this is honorable things that we deal with here. You know, rights of man and privileges and working together so that we all can be successful. Anyway, you have a misdemeanor charge here, and but did you get a copy of this? We can make a copy for you.
Yeah, I'll print out a copy.
And it states that on or about May 5th, that would have been last month. It says you intentionally or knowingly caused bodily injury to William Shaver by striking him about the head and body with your hands. And that was resulting in a Class A misdemeanor of assault, which carries with it up to 1 year in the county jail. Now, that's one thing. Here, you can give that to me and I'll just keep this. And I'll give that copy to the attorney. And so, Mr. Lane, we had some issues on dead batteries here, and I'm going to give you copies.
He's got them, Judge, right there.
I do.
Because this is pages and pages and pages, 4 pages of dead batteries, and that's the problem, is that you are ordered to have a GPS device, and the inference, of course, goes with that obligation is it must be charged, or else it doesn't do anybody any good. And we don't have to say you keep it charged, because that goes without saying. But anything you want to say about the dead battery over and over again? I've got 2, 4, 6, 15, 20, 26, 30, 32, 34, 36, 38, 38 dead battery notices over a period of time from February 1st to 5/21, May 21st. That's
When's
what I have.
the new offense date, Judge, on the complaint you have?
Yeah, May 5th. And so what you have too is you've got a charge filed and a couple of things. Number one, you have to have the GPS and it has to be charged properly, which it hasn't been over a span of months, about 3 months. And so we're not keeping an eye on you. And then here on May 5th, this states you committed this new offensive assault.
And there's a dead battery notification for the majority of that day, Judge, it looks
And
like.
you've got a dead battery on 5/2 and a dead battery on 5/6.
Sorry.
Well,
Judge,
the problem is those are two obligations. Number one, do not commit an offense is one condition of bond. Another one is you have to keep the GPS device charged, which you have not. And so it makes me sticking my neck out to allow you to be on a release has resulted in, we don't know where you are, number one, on these dates where the dead battery is. And then number two, the DA's office has filed a new criminal charge on you during this period of time. All right. Will state want to say anything?
do we know what his bond is currently, Judge?
250,000.
I mean, he can't comply with his bond conditions. He's committed a new offense and he won't keep his monitor charged.
What
And
this is a waste of money.
right. And
It's a waste of bond money.
One time I ain't have my charge in February. She knew about it. Last time I came back to court, you told me. I mean, we talked about it. I'm like,
I didn't say anything about you can commit a new crime.
No.
And you got an assault now that the DA's office has filed just from the other day.
yeah, I don't even know.
Anything you want to add, Mr. Lane?
Well, Your Honor, we're just finding out about the.
Here, you're not gonna have, you're impromptu here. I'm gonna set this for a bond hearing later this week, but your bond is revoked. You're in custody.
Want to hold them out of no bond?
Yeah, a no bond until I can hear everybody's side of this story, and so I can make an educated choice, but all you're doing is making a mess on my watch. When do you want to set this thing?
When?
Friday morning? You gonna-
Yes, or Monday morning.
Anything else?
Can I do some more
That's all.
information on the other case?
Yeah, I'm not gonna be your attorney until you hire me.
I'm
If I can
happy
get
to
you.
print out a copy of the information.
Wait, you have a copy of the information?
I do, Your Honor, and I can get the
Not a copy,
PCs.
Judge.
All right. All you're doing is digging a hole and digging faster. You need to get out of the hole and quit digging. Get out of the hole.
State of Michigan versus Kenneth David Lee.
My client waives his right to the formal reading, was advised his constitutional right to stand mute.
Court enter not guilty plea on your client's behalf as to bond.
Your Honor, on this case, the people would ask for a 10% cash or surety bond and no contact. Your Honor, it does date to October of 24, but it was charged 11/4 of 24. Here we have some concerns given that there was a Swiss Army knife recovered, that the complaining witness said that she had been threatened with a knife, with Mr. Lee saying, "I will fuck you up," and punching her in the mouth as well, with officers seeing a minor injury. Mr. Lee appears to be in custody because he got arrested on the 27th for an incident with his new roommate. My understanding is that the complaining witness in this case has moved out. He now has a new roommate, and that roommate called 911 because of an incident.
So this is the guy that those t-shirts talk about as the guy that doesn't play well with others. It is a bitch that nowadays it pays to have a criminal background check on your new roomie to check that he isn't more used to calling people cellmates than roommates.
However, there is nothing charged in that incident. So I don't know what's going to end up happening with that. That new roommate does not want to move forward. But that we do have concerns about Mr. Lee and dangerousness. So, Your Honor, at this time, we would ask for 10% cash or surety and no contact with this individual.
So, 2 questions. Is it your information that the complaining witness in this case does not live at the East 7 Mile address?
That's my understanding, Your Honor. There's a new roommate now.
Okay. And second question, with regard to the bond request, you know, we've got this whole situation where we're supposed to not set bonds that would only keep, you know, those without funds locked up. And essentially a $500 bond is one that would let anybody with reasonable means post, while a person without means could not post. So would you like to modify your bond request?
No, Your Honor, I'm asking for the money bond because there was a weapon involved, and Mr. Lee does have some priors. He had they date back, but there's gaps in between. So 89 CCW, 2002 OWI, 2006 possession less than 25 grams, 2005 OWI, 2009 A and B, 2015 RNO and OWI third, and then 2024. This year he had a conviction for false pretenses out of 22nd Circuit Court. He just got off probation November 17th of 24, Your Honor. And given that he just got arrested for a different thing, that's why I'm asking for a money bond. If that's considered too high for him to afford, I'm not objecting to an affordable money bond, but that's what my concern is that there's a danger there.
Right. I guess my concern is why not higher as to cover a broader spectrum of the population?
Your Honor, the reason I'm not asking for higher is that while he is alleged to have had a knife and said, "I will fuck you up," there's not the allegation that he then attempted to actually stab her. Although apparently the roommate was concerned about safety. It's because
It's quite out of it hearing a prosecutor give reasons to a judge on why they haven't asked for a higher bond. If you're the defense attorney, you should be paying attention to these points where this guy looks like he's on his last go of Angry Birds.
the new incident, while the roommate called for police, he is not accused of hitting her, that he's accused of grabbing her, and she was afraid he was about to hit her. So we have concerns for safety, but the kind of assault we think might happen might be a less serious assault. So that's why I'm asking for that dollar amount. If the court thinks it's not appropriate, of course, the court can do something else, but that's why I'm asking for that dollar amount.
Thank you. Mr. Bird.
So we have a incident that we're bringing up in which my client's not going to be charged, and then we got a complaining witness that says today.
Are we sure he's not going to be charged if he was picked up on the 27th?
I should say hasn't been charged. Then let me put it like that: hasn't been charged, and we have a defense. We have a complaining witness who states that she does not wish to prosecute in the case, and he did not hit her. So
I thought Ms. Douglas said she does want to prosecute.
The current case she wants to prosecute. The new one, she says she doesn't want to prosecute.
Okay, thank you. Sorry,
Right.
Mr. Bird, go ahead.
no problem. The 62-year-old lifelong resident of Michigan, Your indicates to us that he's not on probation and parole and doesn't have any pending cases. He's a Marine Corps veteran, works at the VA hospital, Your Honor, but is unable to afford any bond. This did happen a little bit of time ago, roughly about 2 months ago now or so, Your Honor, and the complaining witness doesn't live at their location anymore. My client indicates to us that he was jumped by the complaining witness and her boyfriend when he asked the complaining witness and her boyfriend to leave his house. And that might be because there's a lot missing to this story. We have an indicate says she was in where the complaining witness says they were engaged in a disturbance with Kenneth Lee, who hit her in her mouth. Now I don't see where it says that anything about minor injuries in my report. So I don't see anything about injuries, and I believe what's missing is important was there, Your Honor. Oh, I see shoulder minor. I do see it now. Miss Pearman, shoulder minor injury to her mouth. But and then it says he stated, "I will fuck all of you up." Now, first of all, when told the story by the complaining witness in this matter, he's saying that she says, "I will fuck all of you up," but who is all of you? It's the people that were jumping him. It's the other person that was jumping him. So they're not stating there's a reason he pulled out a knife. It doesn't say. So it's only telling one side of the story, and I believe we need to give my client's side of the story some light too, Your Honor. So respectfully, we're gonna ask this court for a personal bond. He doesn't have any problem with not contacting the complaining witness. Actually, he doesn't want to be around the complaining witness and was asking the complaining witness to leave in the first place, and that's the reason he was jumped. So respectfully, we're gonna ask this court for a personal bond in this matter. And I do
Thank
want to
you.
say,
Sir, while,
sorry, Your Honor. I'll let you go.
sir, while this case is pending, you're not to possess a firearm, a knife, or any other dangerous weapon. Is that clear?
Yes, sir.
Additionally, you're not to have any contact with Ms. Perrin for any reason. These allegations did arise at the defendant's home. Apparently, the complaining witness has moved out of that home. Court does have some concern about the second case, which may or may not get filed, also occurring in the home with the complaining witness who is living with the defendant, similar fact pattern to this. But all that being said, court will set bond at $10,000 personal. Thank you, sir. You can step aside.
Thank you.
And just for good measure, the triple effect.
So we're
Hey guys, it's me. I wanted to let my subscribers that stay to the end know that I have an episode coming out next, and it contains one of my thoughts on the sovereign citizen defense. It's funny as that defense usually is, but I also think what I say hasn't been said before. Yet I think it is that most of us would agree with. But that is all speculation until you see it. So please check the bell icon, as I want to read what my subscribers who watch my videos through to the end think, as it really is you guys that are my subscribers who like my stuff better than the rest. And that for me means a lot. Remember, bell icon, so you can tell me if my opinion holds water, which now reminds me to take a bath.